A Superior Court judge has ruled against Lieutenant Governor Dan Forest in his lawsuit against Governor Roy Cooper. Joining us now for expert analysis on the latest developments in the Forest v. Cooper case is Jon Guze. He is Director of Legal Studies at the Locke Foundation. John, first, your initial reaction, Judge Gale denying this motion for a preliminary injunction in the case of Forest v. Cooper.
Well, a couple thoughts. It's only a motion for preliminary injunction, so we're a long way from deciding the merits of the case. We'll get to some of the reasons why it's a little bit more discouraging than that, but I think that's the main takeaway. We're just at the early stages. We don't really know how this is going to play out.
Now, you mentioned that this is just on the preliminary injunction, and one thing that is significant is Judge Gale says that he is not acting in this order on the governor's motion to dismiss the case out of hand. That is something that is not determined at this point. What significance should we read into that? Well,
that's the most important thing. That's going to probably be the part of this case that gets to the Supreme Court. I wouldn't be surprised. If Judge Gale had dismissed it, then that would be the end of it, and the lieutenant governor would have to appeal and so on. But all that was at stake here was a preliminary injunction. I really didn't expect Gale to grant it, although I wish he had picked from the point of view of those of us who've been skeptical of the governor's power to do these things, we would have preferred him to have used to have denied the motion for a different reason. He could have denied it, for instance, on the grounds that allowing these orders to stay in place wouldn't have done any irreparable harm to the governor. So I actually expected him to deny this motion on the basis of what they call the balance of equities. I think he would have said, well, on the one hand, if we lift the order, there's some risks. Keep it in place, maybe there's some risks too, but on balance, we think the public good is better served if we allow the order to stay in place until the merits of the case are decided. But he didn't use either of those reasons. He denied it because he concluded that the lieutenant governor was unlikely to succeed on the merits, and that's a little bit discouraging. That means that on the basis of what he's seen up till now, he's not impressed. But we'll get into some of the details. It's not as bad as it could have been.
Yeah, you alluded to this and then just gave us some more details. The fact that this is not just denying the preliminary injunction, but saying, hey, this case can go forward and perhaps the lieutenant governor can win at another level. Superior Court Judge James Gale is ruling in this case. He doesn't really think, based on what he's seen, that Dan Forest has a case.
Well, not so far. But I mean, again, it's only a preliminary injunction, and he hasn't even ruled on the motion to dismiss. So there's plenty of time to get some more evidence in front of him. It's interesting. Judge Gale obviously likes evidence. He's not pleased when somebody comes before him and just tries to make an argument without supporting it with some facts. And I think that's part of why this went the way it did. If you read the opinion, you'll see that he makes a good deal of the fact that Governor Cooper, he submitted declarations from a number of people. Jordan Wichard IV, who's the Director of Intergovernmental Affairs in the Office of the Governor, Eric Hooks, the Secretary of the North Carolina Department of Public Safety, and Elizabeth Tilson, who's the Chief Medical Officer for North Carolina Department of Health and Human Services. All of them made declarations in support of the governor's position on this, and he notes that the Lieutenant Governor Forest did not respond to the declarations and did not argue against their assertions when given the opportunity to do so at a hearing. I think that was a strategic mistake. We've seen in the past in this and in other cases that Judge Gale likes to see some facts presented to support positions that are argued in his courtroom.
Let's get into some of the specifics of the ruling. The main piece of this seemed to do with two sections right next to each other in the State Emergency Management Act. One that says if the governor is going to exercise some emergency powers on a statewide basis, he needs the concurrence of the Council of State, which is the 10-member executive branch elected officials from North Carolina. The very next section allows the governor to act with emergency powers in his discretion if he sees that local governments cannot address an emergency on their own. And the fight between Forest and Cooper on that front seemed to be about whether Governor Cooper's executive orders dealing with COVID-19 fall under the first section requiring the Council of State's concurrence or the second section. The judge seems to go along with Governor Cooper in saying that these orders seem to go with the powers that are granted under the second section, which does not require the Council of State.
That's right. I mean, there's no question. Governor Cooper has not obtained concurrence from the Council of State for any of these orders. So to the extent that he's relying on that first of those two sections, he's exceeded his powers. So because of that, he's arguing instead that he's got these powers because he has made a determination that local authority control is insufficient. Now, and that's why these declarations I referred to before are important, because the governor came back and provided these declarations, all of which supported his position that local control was insufficient. The lieutenant governor didn't have an answer to that, and he should have, because that's what it really comes down to. If, in fact, the governor did make the proper determination and determine correctly that local control is insufficient, then he's got the power to do these things. It all turns on that. And in this case, we didn't have a good factual showing on the lieutenant governor's side.
One of the other interesting things is that part of Lieutenant Governor Dan Forest's argument relies on this notion of checks and balances, separation of powers, and that one of the reasons why the Council of State is supposed to oversee the governor's orders is that it's a check that's put in place as part of the State Emergency Management Act. Judge Gale makes quite a point that whatever happens in the executive branch, whether the Council of State's involved or not, the General Assembly still could step in here and take steps to check the governor. What did you make of that piece of the argument?
Well, I didn't really go along with that. I personally think that requiring concurrence of the Council of State is a very important check on the governor's emergency powers. And I don't think it can be brushed aside that easily. Sure, the General Assembly can come back and change the language of the act, and I hope they will, quite frankly, because part of why we're having all these problems is because the act isn't sufficiently clear on these things. So I would hope that eventually the General Assembly will amend the act and make it clearer. But when they do, I want there to be some checks on the governor's power. So I think Judge Gale was a little too hasty in dismissing that argument, although it could have been presented better perhaps by the lieutenant governor.
Speaking of hasty, I don't know if this is the way we describe it, but perhaps dismissive would be another way to describe it. One of the pieces of the lieutenant governor's argument involved quarantine laws and saying that the governor also violated quarantine laws by not going to a court at least once every 30 days to make sure that these shutdown orders complied with what a court would find acceptable. Judge Gale goes along with the governor in this case and says, it's not even a quarantine. This doesn't apply.
Well, but remember, the governor at one point was arguing that part of his power to do these things came from that statutory power under the quarantine provisions. The governor stepped back from that because clearly these things are not quarantines. A quarantine is when you require somebody to stay in some kind of isolation because they have a disease, but that's not what's going on here. People who are being locked down or forbidden from opening their businesses they don't suffer from the disease. They're just being told to do this in order to prevent the spread. So that's basically become moot. The governor's given that up, and it doesn't really matter anymore in this case going forward.
One other piece of this argument I want to touch on, and we discussed this when we initially talked about the filing in Forrest v. Cooper, is that there is a bone of contention between Lieutenant Governor Forrest and Governor Cooper about whether the Lieutenant Governor even has standing to file this case. Judge Gale sidesteps that argument and says, if this is going to be resolved, it'll be resolved when I deal with this motion to dismiss. What do you think about the Lieutenant Governor's standing and whether he's going to be able to proceed with this case at all?
I think he's got standing. I don't take that argument very seriously. I mean, the governor is going to always make an argument that the plaintiff lacks standing, but I think the Lieutenant Governor clearly has standing here. If, in fact, but again, it all turns on which portion of the Emergency Management Act applies. If, in fact, he succeeds in his argument that local control was insufficient, then the standing issue will be moot again because it just doesn't matter. The Council of State doesn't come into it.
Now, it's possible that Lieutenant Governor Forrest could appeal this decision to a higher level of court, or he may just allow the court to proceed in front of Superior Court Judge James Gale in dealing with the motion to dismiss and any other matters that come up. What are you going to be watching for as this case now proceeds?
Well, with all these cases, the way these motions proceedings play out determines pretty much whether these things matter at all. Because unless we get a preliminary injunction or a motion to dismiss, we're not going to know who wins on the merits in time to really matter. Assuming, as I do and hope and pray, that COVID doesn't stay with us for years to come. But if it fades away in the coming months, as I hope and pray it will, then all that matters at a practical level is how these early motions proceedings play out. So far, this one hasn't gone the lieutenant governor's way, but it's going to be much more important to see what happens when Judge Gale considers the motion to dismiss.
Well, it's certainly a very important case. It is Forrest v. Cooper, pitting our Lieutenant Governor Dan Forrest against the Governor Roy Cooper. You've been listening to expert analysis from Jon Guze. He is the Director of Legal Studies at the John Locke Foundation. John, thanks so much.
Thank you, Mitch.